May it please your Lordship. Your Lordship, I beg to mention item number 10 and 11. Your Lordship, the judgment they're relying on, the petitioners, it has gone for appeal in the division bench, Your Lordship. It is still pending. The next date is on 15th of May, Your Lordship.
Who's appearing for the?
Your Lordship, Mr. Chanda.
Have you sought their?
Yes, Your Lordship.
3 weeks.
Much obliged, Your Lordship.
But I beg to make a mention of item 7 below. State respondents. I don't see.
I'm for respondent number 9, Your Lordship.
Your Lordship, they have taken lately regarding the.
Well, what had happened in the last occasion, I received the instructions.
I have not started.
My lord, I could not finish it.
No, have we started?
No, there was no hearing. My lord, subsequently what had happened, they had filed an amended petition.
Yes, so that was
It's a
allowed.
matter of
My lord,
one point.
so
Lordship.
I forwarded the copy to the department. Only recently I have received the instructions. So I could not complete, my lord. So kindly allow a little more time.
Your Lordship, final chance may be given, Your Lordship. Final chance may be given to the respondent. Your
It's
Lordship.
an old matter.
My lord. In that event, my lord, kindly allow 3 weeks.
1 week.
Because next week, most probably I'll be out of station for 2-3 days.
And moreover, Your Lordship, like in my matter, like this, for the respondent number 9, also the learned conducting causing also required time, Your Lordship. So 3 weeks will be suffice, Your Lordship.
But previously, Your
2 weeks.
Lordship, the respondent said that they will not file the appeal.
No, they are not filing.
One of the counsel is Mr. S. Jindal. my lord.
Yes, Your Lordship.
So he's for
Jindal.
respondent.
9.
He's for respondent number 9.
2 weeks and no more agenda.
My lord.
Much obliged, Your Lordship.
Lordship.
My lord, item 9 has some difficulty today, my lord. It is taken up after 2 weeks.
Why?
My lord, I need to go through the case record properly. I'm the newly engaged counsel, my lord. Kindly allow a little more time. One of the affidavits is missing, I think, so I need some copies from the.
You are there in this case?
Your Lordship?
You are there in this case?
Yes, Your Lordship. And for the respondent.
One of the respondents.
2 weeks.
2 weeks.
Obliged, Lordship.
Obliged.
May it please your Lordship. Lordship, items number 3 and 4 of the daily list are fixed for hearing. I filed my affidavit for respondent number 6 in the course of the day, my lord. However, for respondent number 7, he was accused of instigating the recent turmoil in Garhwals, my lord, and as such, he has surrendered before the police. I need some more time to seek instructions from respondent number 7. For respondent number 6, I'll
3 and 4.
3, 4,
Items
5,
number
Your
3 and
Lordship.
4.
5 also, Your Lordship.
Matter has been heard.
No, Your Lordship.
Not heard.
This is a 2022 matter.
Yes, my recently we had filed applications for recalling orders by which our affidavits were closed. Your Lordship was pleased to grant us
Okay,
Lordship
you
will
are,
find you-
oh, you have to file the
affidavit.
counter.
my lord, Yes.
You are the school.
And
They are
the
the earlier
ex-secretary
managing committee, Your
and
Lordship.
Earlier managing company.
ex-secretary and president of the school.
Is it a case of termination or
No appointment, Your Lordship.
Appointment of the teachers, Your Lordship.
so the petitioner has not been appointed?
Madam, in my case, the constitution has been challenged, the constitution of the managing committee, madam. In respect of the same school, madam.
No, let's in
3, 4, Your
Lordship,
Lordship.
Three.
items 3 and 4, Your Lordship, the petitioners have
in
not
3
been
and 4
appointed.
Lordship,
petitioner.
those who have been selected have been appointed.
Okay, but they have not been appointed.
No, Your Lordship.
No, they have challenged
Yeah,
the
they have
appointment,
challenged,
Your
they have
Lordship.
challenged.
Your Lordship, the
How many-
petitioners have started their arguments, Your Lordship, in fact. We had started our arguments, then the confusion was there with regards to the other respondents, Your Lordship.
See, what happened is you also have to consider, you see, at the end of the day, it's difficult for the court to balance the equity.
Yes, ma'am.
In the meantime, the incumbent would have, been in service for quite some time. They would have acquired some sort of rights. Now, again, it's the court
Take them
cannot
back.
the court cannot direct if you have a case. The court cannot direct for creation of posts. that's a policy matter.
Then
So
let it
now,
be 2 weeks only, Your Lordship.
I don't know.
Let it be 2 weeks only, Your Lordship.
2 weeks then,
Lordship.
and no further time.
Lordship, yes.
You have not filed.
For respondent number 6, I'll be filing in the course of the day. Respondent number 7, we could not get instructions because he has recently surrendered before Nongpa police,
Okay. Oh, because of that.
Mr. Esmatul Mominin. So we could not get in touch with him, my lord, for instructions.
Then 2 weeks, Your Lordship.
3 weeks then.
3 weeks. Apply, Your Lordship.
Much obliged.
So that is 3 and 4.
3 and
3 and 4.
Yes.
And what would is 5?
5
5,
also is
let it come
connected
along.
with-
Let it come along.
Same order.
Lordship, yes. Apply, Your Lordship.
May I please, Your Lordship, I beg to mention under Art number 12. May this matter come after 2 weeks?
No objection, Your Lordship.
Mr. Jindal has not yet
Not will join, Your Lordship. Most probably from next week.
next week.
Yes, Your Lordship.
2 weeks.
Obliged.
Much obliged.
Supplementary list item number 1.
Made clear, Your Lordship. Here in this case, we have filed additional affidavit as Your Lordship permitted on last occasion. That is probably on in record, Lordship. Lordship, may I kindly see page 8 of that affidavit, Lordship. Page 8. This is the FIR. May I read, Lordship?
Yes.
With reference to the subject cited above, it is to inform you that the joint magisterial team was deputed to conduct raids and seize the illegally dumped stored coal in and around Gosuapara land and custom station based on the police report submitted by letter number so-and-so dated so-and-so. So-and-so executive magistrate conducted the raids and also the seizures on 27/6/2023 and on 30/6/2023. Around 5,711 metric ton of coal dumped illegally was seized by the magistrate from one firm named Vaishno Devi Traders Private Limited, which belonged to Sri Balwan Bhama. The said seized coal was assessed on the spot by the Mines Royalty Inspector Gosuapara. So this is the affair. From here, Lordship, just I am pointing out one thing to your Lordship, that they use the word dumped illegally. So at the initial, my submission would be, and from the record also I will place before your Lordship, that from the day one they knew that it was legally procured coal, Lordship. So it was not illegal coal. That is one aspect of the matter. So now I am taking your Lordship to my petition, Lordship. Lordship, may I kindly have the petition first now.
Yes.
Page 38, Lordship, may I kindly see. They purchased the coal in e-auction, Lordship, and that Lordship, Director of Mineral Resources issued these tax invoices. And this continues to Lordship that page 53, all the tax invoices are annexed here, Lordship.
Yes.
Issued by Director of Mineral Resources, Meghalaya, Shillong, Lordship. And then your Lordship may kindly see page 54. This is the order issued by Deputy Commissioner in pursuance to the letter issued by the Director of Mineral Resources, Meghalaya, Shillong, by letter number so-and-so. The permission is hereby granted to Vaishno Devi Traders Limited, successful bidder of 12,500 metric ton of coal auctioned by CIL in temporary designated depot number 2 located at Madan Khair Palaigang, so-and-so, Jantia Hills District, so-and-so, to transport the auction coal as per mineral transport challan shown below. So this permission was there. And kindly note that part, Lordship, may see that note is there, serial number 8. The route approved is from Madan Karan Pailiang, Nongtiong to Bangladesh via Gosuapara. The route allotted should be strictly followed. So these coals were seized from Gosuapara, Lordship. Now the other page, next page, your Lordship will find. This is the order of Director of Mineral Resources, and in terms of these orders, that order was passed by the Deputy Commissioner, which I have read, Lordship. The other orders, your Lordship will find page 55 and 56. Now this document shows that these coals were legally procured by the petitioner, Lordship. Now Lordship may kindly see page 61, prior to lodging of the present FIR, Lordship.
Yes.
Page 61. This letter was addressed to the Deputy Commissioner by the present petitioner, Lordship, which was duly received by him on 9/6/2023. There was some threatening on his part, so therefore he requested some protection, Lordship. So first paragraph I am reading, that part your Lordship may kindly say page 61.
Yes.
I hope this letter finds you in good health and high spirit. I am writing to bring to your attention an urgent matter that requires immediate attention and intervention. I am writing on behalf of MS Vaishno Devi Traders Private Limited, a successful bidder of coal from Coal India Limited, brought coal and export from Gosuapara, South Garo Hills, Meghalaya. So what I am pointing out from this paragraph is that subsequently, Lordship will find that while filing charge sheet, they said that I have never informed that I have legally procured this coal. So because of this, Lordship, I am pointing out the first paragraph. So it was prior to lodging of the FIR, I have informed the Deputy Commissioner, because Deputy Commissioner is the informant in the present case. Now Lordship may kindly see page 107. This is the Depot Manager of Director of Mineral Resources, certificate issued by him on 13 September 2023. And he is one of the, Lordship, charge sheeted witness. And on my instruction, he was examined by the investigating officer. Therefore, I am pointing out to his certificate, Lordship, 107. This is to certify that MS Vaishno Devi Traders Private Limited was a successful bidder of 12,500 metric ton of coal facilitated by Coal India e-auction in March 2023 under the Honorable Supreme Court order dated so-and-so. In its the company has cleared all the payment regarding coal bidding amount, royalties, sales, so-and-so, etc. The mineral transport challans have been issued from the head office, that is Directorate of Mineral Resources, Risa Colony, Meghalaya, East Khasi Hills District, by NOC memo number so-and-so dated so-and-so. And the details of the mineral transport challans are shown in the NOC issued by the head office. NOC copies enclosed. As per records from DMR Gosuapara check gate, the challans which was issued on 14/4/2023 and 2/5/2023 have already crossed the check gate exporting to Bangladesh, and the MTC issued on 28/6/2023 coal has already been lifted from depot to Madan Karan Pailiang Road, East Jayantia Hills District, and till date it is not export to Bangladesh through Gosuapara. So then your Lordship may kindly see page 109. Here also that the present petitioner informed that he purchased all these all these things, and Lordship, he also informed that he can be contacted in an email ID. That email ID is there, Lordship, mentioned here. Your Lordship will have page 9 down below, just above his signature. Why I am pointing out, because here your Lordship will find that the name is Joy Ma, M-AA, and in the charge sheet they said they have sent notice to me in Joy Ma, in singular, Lordship. That is why I did not receive any notice. That is why I am pointing out to your Lordship, and that is the difference, that M-AA, and in the charge sheet they said they send the copy to M-A. That is the difference. And now second thing, another aspect your Lordship will find that after registration of the case, he filed one quashing petition before this honorable court, and as there was a prima facie allegation, so that was dismissed, Lordship. Against that order, he went to Apex Court, and Apex Court given him liberty to file the additional documents before the investigating officer. That, your Lordship, will find page 136. It is dated 15/4/2025.
Yes.
We are not inclined to interfere with the impugn order passed by the High Court. The special leave petition is accordingly dismissed. However, we grant liberty to the petitioner to produce all such material along with the representation, as he wishes to rely upon, before the investigating officer, which shall be considered by the investigating officer during the investigation, and if already submitted, the investigating officer shall consider the same. Although I have submitted prior to that, but still, Lordship, after that order, at page 137, your Lordship will find I have given all the documents again to the investigating officer, which was duly received by him on 28/5/2025. Page 137.
Yes.
Page 1 copies, Lordship, may I see that copy of trade license, e-auction, and payment confirmation.
This reference of to page 136.
Yes, Lordship.
Where is the High Court's order?
No, this is the Supreme Court order, page 136.
Where is the High Court's order?
High Court order, yes, is at page, Lordship, 131.
What does it say?
It says, Lordship, there is prima facie case and no new documents can be seen at this stage, Lordship. On that ground, it was dismissed. Paragraph 5 and 6, Lordship, may I kindly see page 134.
So this FIR
Lordship.
is the same FIR.
Same affair. That is the Gosuapara PS case number 47 of 2023. That reference, your Lordship, will find at page 132. 131 also, in the first paragraph also that case number is mentioned. First paragraph. One aspect was not pointed out.
Now,
Lordship.
this is an FIR of 2023.
Lordship.
Investigation has been launched. Perhaps charge sheet may have been filed.
Lordship.
So what remains?
That
Now,
I have annexed, Lordship.
You may have joined investigation.
Lordship.
So at this point of time, you have come for anticipatory bail.
Lordship, because
in
Lordship, they
connection
have
with this FIR. Why?
Lordship, because they have shown me as absconder in the charge sheet.
Absconder.
Absconder in the charge sheet. Therefore, I have pointed out all the.
But you have not taken part in the investigation.
I have taken, because in fact, if your Lordship sees page 137.
Because according to the direction of the Supreme Court,
Lordship.
you are to produce all documents, whatever, to the IO,
Lordship.
which you, according to you, you have done so.
Lordship.
So it means that your presence would have been recorded in the records.
Lordship.
You have appeared, you or your agent or whoever,
Lordship.
but you have appeared. So
That
why
your
would
Lordship will find page 137.
yes, but why would you be?
Page 137 for a moment, Lordship.
Yes, that's what.
This is to the investigating officer, and this was received by the investigator. Down below, your Lordship will get it. It is after the Supreme Court order 28/5/2025.
Exactly.
And now Lordship may kindly see the charge sheet at page 137. Why I am aggrieved, Lordship may see page 143, that relevant part. (143) after that tabulation, during investigation, Lordship.
Yes.
During investigation, the previous IO issued several notices against the accused Sri Balwan Bhama, making a total 5. But the complainant did not comply with any of these notices. Firstly, the notice was issued on 19/7/2023 through Sri Dipendra Arya, the caretaker of MS Vaishno Devi Traders Private Limited. Secondly, the notice was once again issued through Sri Dipendra Arya on the 9/8/2023. Said third notice was also issued in the hand of Sri Dipendra Arya. The fourth and fifth notice was also issued in the hand of Dipendra Arya. Also send the same notice through mail in the email ID, namely Jayma. Here, Lordship will find that 1A is missing, and because of that, Lordship, I did not receive any notice, Lordship, and therefore I could not personally appear before him, although I have given all the relevant documents. And here also, the last second paragraph. During investigation, the previous IO enlightened that the owner of MS Vaishno Devi Traders Private Limited, Sri Balwan Bhama, has been granted special leave petition. So how he came to know that special leave petition order, that your Lordship will find, because the representation which I have already just now I have placed before your Lordship at page 137, that enclosed that order. Because of that, he knows that special leave was filed.
Here you see the accused neither produce any such document before the.
He is saying contradictory, which is contradictory to page 137. That order was given by the petitioner himself. And then your Lordship may kindly see
this page 137.
Lordship.
You have the receipt.
They have received with seal and signature also. That down below, that seal is there.
This is the one.
Seal of Superintendent of Police, dated 28/5/2025. Number is there, 294. At serial number 7 of that representation, he has enclosed that Supreme Court order.
Yes.
And now, Lordship may kindly see page 144. During investigation, a prayer was made before the additional district magistrate whether MS Vaishno Devi Traders Private Limited had any authorized permission for dumping, storing the coal in and around Goswapara or not. But the additional district magistrate J. White, letter number so and so, informed that MS Vaishno Devi Traders Private Limited does not have any requisite documents, information for dumping, storing of the coal in Goswapara area. So what I understand, subject to correction, what my learned senior friend says, Lordship, that the whole allegation is regarding dumping of the coal illegally. Now, if we take it to be true, Lordship, even then they have to give me 15 days notice to remove that coal. There is a rule, Lordship, of Meghalaya High Court. Just I have got print out for your Lordship's convenience. Rule 12. Lordship may kindly have a look at Rule 12.
Yes.
Rule 12. Authority to cause notice, seize or auction of the material stored in areas other than the designated storage area. 1. The competent authority or any other officer, authorized officer shall have the power to serve notice to any person, firm for removal of any mineral stored other than in the designated storage area. 2 is important, Lordship. The competent authority or any other authorized officer shall, after expiry of 15 days notice issued sub rule 1, seize any material in possession of any person stored in areas other than designated storage area. So they could have seized after expiry of 15 days notice, Lordship. But neither the FIR nor the charge sheet anywhere shows that any notice was issued to remove those coals from that area, Lordship. That illegal dumping will come only after that 15 days period.
Yes, Mr.
May it please your Lordship. Lordship, first my objection to the bail application is that, your Lordship, the bail applicant here in your Lordship has come directly before the High Court, your Lordship. He has not moved before the learned court below, your Lordship. And to that, your Lordship, if Lordship kindly have this order of the Honorable Supreme Court, your Lordship. Lordship kindly have paragraph 6. May I read it, your Lordship?
Yes.
However, before parting, we do wish to express our sincere concern with the haste in which the High Court has dealt with the. While the scheme of Criminal Procedure Code 1973 now BSNS provide concurrent jurisdiction to the High Court and Session Court for entertaining application for this court has time and again observed that the High Court should always encourage hosting an alternative concurrent remedy before directly interfering itself. This approach balances the interests of all stakeholders, first by giving the aggrieved party a round of challenge before the High Court. Second, this approach provides the High Court an opportunity to assess the judicial perspective so applied by the Session Court in concurrent jurisdiction instead of independently applying its mind from the from the first go. Further, the High Court failed to record Lordship. So, Lordship, first, my contention is the bail applicant ought to have moved before the Session Court first.
Yes.
So on this count also, your Lordship, this bail application, your Lordship, in my humble and respectful submission, your Lordship, cannot be entertained, your Lordship. The bail applicant, he may be asked to approach first the session judge. Only after the rejection or whatever order passed by the learned session judge, then he is at liberty to approach before this court. Then on merits, your Lordship. Lordship, kindly, my friend has shown, your Lordship, the order passed by this court, your Lordship, in that question petition. Lordship, kindly have again at page 134. It start from page 133, your Lordship. Paragraph 4, that is the reproduction of the FIR, your Lordship.
Yes.
Then at page 134, your Lordship.
Yes.
134, your Lordship. Then, Lordship, at page 135, your Lordship, at para 7, it reads, your Lordship, the contention of the learned counsel for the petitioner that the seized school was acquired illegally by paying all the royalties and other taxes and the supporting document thereof annexed with the instant criminal petition cannot be gone into by this court at this juncture in exercise of its limited jurisdiction under section so and so in order to record a finding as to the legality or illegality of procurement of the seized school. Then, Lordship, again, this order, your Lordship, especially have been filed before the Honorable Supreme Court, your Lordship, at page 136, your Lordship. And the Honorable Supreme Court, your Lordship, has granted that liberty, your Lordship, to produce whatever materials, your Lordship, before the investigating officer, your Lordship. Then, Lordship, kindly have page 137. The so-called letter, your Lordship, dated 28/5/2025, your Lordship, who has submitted this letter, your Lordship? The letter indicate no signature at all, your Lordship. Because the order of the Supreme Court, your Lordship, it says, however, we grant liberty to the petitioner to produce all such material along with the representation. The liberty of the Supreme Court, your Lordship, is to the petitioner, your Lordship.
Yes.
Not to the second or third person, your Lordship. And whatever, be that as it may, your Lordship, page 137, your Lordship, no signature has been seen, your Lordship, in that letter. Whether this, so who has sent this letter, your Lordship? That is not, we have no idea, your Lordship. Then, Lordship, kindly have the charge sheet. The charge sheet that had been filed, Your Lordship. Lordship, kindly have page 143.
Yes.
During the investigation, the previous IO enlightened the owner of the so-and-so has been granted especially and has been asked to produce all the material before the investigating officer, and the accused neither appeared nor produced an asserted document before the investigating officer. Then next, similarly, notice under section 35(3) BNSS was also issued. In spite of the fact of that liberty granted by the Supreme Court, Your Lordship, to the petitioner to submit whatever materials before the investigating officer, that has not been done, Your Lordship. He neither appeared nor before the investigating officer, and that too also in spite of the fact that a notice under section 35(3), Your Lordship, had been served, that also he failed to appear, Your Lordship. So it shows, Your Lordship, that the bail applicant here in Your Lordship is not willing to cooperate with the investigation of the case, Your Lordship. So my humble and respectful submission, Your Lordship, the bail applicant being an absconder, Your Lordship, as seen from the charge sheet, Your Lordship, he is not entitled to the grant of the privilege of the pre-arrest bail, Your Lordship. These are my contention, Your Lordship.
One thing Your Lordship may kindly see that page 138, this charge sheet was submitted in the court of special judge, Lordship, that will be Lordship session judge. So he will be the trial court and there is no committal court, Lordship. So if I file any application, I have to file under section 437, earlier 437, Lordship. Then he will have to remain in present in the court, and if his application is rejected, he will be taken into custody. That is the apprehension because of which we have directly approached to this honorable court, Lordship.
What is the stage of the case? Evidence?
Lordship,
no,
I'll have
for
to...
Appearance.
I'll
for
have...
appearance.
Oh, for appearance.
Appearance. He entered his appearance through an engaged counsel, but he could not appear personally because of this apprehension, Lordship.
I have not sought instruction, Your Lordship, regarding the state of the case, Your Lordship.
But I think in view of the Supreme Court's observation, you should have approached the trial court.
No, that 439, earlier 439 and now 482, Lordship, that probably will not...
No, even for grant of anticipatory bail, you could have approached the court concerned.
No, that court, in Lordship, that court is having that records in that court itself.
It doesn't matter.
Lordship.
It doesn't matter.
Lordship.
The court has got the jurisdiction to take up your application. In the event of, as the AG has said, even that is rejected, you can always approach this court.
Yes, Your Lord.
Probably that citation which my learned senior friend has placed, probably that is not the court where that probably committal court is there.
No, it's not.
In that case,
I don't think that is the. What is intended is for the parties not to lose any forum.
Lordship. That is there, Lordship.
But see, since there's an observation by the Supreme Court.
No, in that case, Lordship, that 302 was there.
So the principle is same, Your Lordship.
We're not looking at the offence involved.
Lordship.
We're looking at the procedure.
The procedure and the principle.
The principle. Now, this is the observation made by the
Honorable Supreme Court, Your Lordship.
It would be difficult for this court to go against this observation.
Lordship also will kindly recall also there is an observation also made by the Supreme Court, Your Lordship, so far that order of pre-arrest bail from Kerala High Court, Your Lordship, but I could not get that, Lordship.
You have waited for so long. It's since almost 3 years now.
Lordship.
Rightly or wrongly, you have not been arrested.
Lordship.
So even because of passage of time,
no.
the whole idea of apprehension of arrest
Lordship.
has got diluted. On top of the fact that since you have been shown as an absconder.
Absconder.
So it is incumbent upon you to make your appearance for the court.
Lord.
If, let's put it this way, even if you are arrested, you can always apply for regular bail or file for, like the usual practice you have just pointed out just now.
Lordship.
You can file for regular bail before the trial court.
Only to hear his lordship 62 years old or
True,
62.
and I don't think, in all probability,
Lordship.
since the matter has already been charge sheeted and has proceeded for further trial,
Lordship.
then there's no question for requirement of interrogation or questioning as far as you are concerned. So that,
Can this matter be taken up after 15 minutes, Lordship? By this time, I will just go through that judgment, Lordship. After 15 minutes, Lordship, I will.
you just go to it and the related judgment and see.
If anything is there, I will place before your Lordship.
If you wish to withdraw and file before the trial
After
court.
15 minutes, I will.
Lordship, can you see also the charge sheet is of 15/9/25, your Lordship. Now we are in April 26.
Can I see it?
You have not given a copy. Fine. Pass over.
Apply.
Item number 2.
May it please your Lordship. Lordship, the applicant here in a preferred appeal against the conviction order under section 304 of IPC Part 2, your Lordship. However, your Lordship, there's a delay of 130 days, your Lordship, in preferring the appeal, your Lordship.
Delay condone.
On daily list, item number 1.
Highly obliged, your Lordship.
Lordship, I'm seeking for some more time to file my counter, your Lordship. This will be the third time I'm praying, your Lordship.
What is your prayer here, Mr. C?
My prayer has already been addressed by my lords by granting us a status quo ante. They have already defrozen the accounts.
Okay, so
So they need to, that's my suggestion last time was that also that nothing much survives in this matter now.
Yes,
This
so-
matter can be disposed of. If they have to do it, they have to do it as per the law, that's all.
So you have filed this petition.
Yes, my lord, I have filed this petition because what has happened is the deputy commissioner, my lord, did the freezing of the bank accounts which without any powers. So all I am saying is the matter is now, since my lords intervened and granted us a status quo ante and he has defrozen the bank accounts himself. Now nothing much survives.
Then you will withdraw the petition.
Yes, I or my lords can dispose it off in terms that matter has become infructuous now.
Exactly. On your submission, the matter will be disposed of.
But my lord, the only the difficulty is he has only withdrawn the notification by virtue of which he has frozen the account. But he must not. He has to act as per the law. That's only indulgence. If I withdraw, the difficulty is if I withdraw myself, my lord, that means I accede to his actions what he did earlier. That is why I am seeking that the matter be disposed of, that the matter has become infructuous. They have already done the needful.
Fine.
That's all. Order is dated 17th of December 25. That interim order.
heard Mr. A.P. Singh, learned counsel for the petitioner, who has submitted that the prayer of the petitioner university is directed against a letter dated 15/2/2025 issued by the Deputy Commissioner
Yes, my lord.
Shillong,
Reboy district.
issued by the Deputy Commissioner Riboi district, wherein the relevant bank account of the petitioner university has been freezed. This court next write an interim order dated 15/12/2025 has directed the said Deputy Commissioner to reverse the decision taken, that is to defreeze the said account.
Accounts, my lord. Said accounts.
Said
Because there are
accounts.
some 600 and odd accounts.
Said accounts which according to the knowledge, which is in the knowledge of the petitioner, that the said direction was complied with. Is there any communication?
There is, my lord. We have not. They were supposed to, my lord, place it on because they communicated with the bank directly, so they did not give us any But our bank gave us a statement that it has been defrozen now.
So who to play last? Stop. Next. Though there is no official communication of the said action of the Deputy Commissioner, the petitioner university has, however, been informed by the bank that the said accounts have since been released from being since been defreezed. Accordingly, in view of such action taken, the Learned Counsel for the petitioner has submitted that this petition has become infructuous. Next, Mr. appears for the respondent. This court, on consideration of the submission made, would agree with the contention with the submission of the Learned Counsel for the petitioner, and accordingly, this petition is hereby disposed.
No, infructuous.
As infructuous. Next, the interim order pass is hereby made absolute.
But there is only one indulgence I am seeking. There are 28 accounts and there are some 600 and odd persons my name was also there, and all other senior advocates, whoever the university had paid, they were all, my lord, some of them were, including me, my lord, were defrozen, but for others, my lord, they had not filed the writ petition. So this order, my lord, need to go also, the 15th of February, the impugned order.
In fact, we have not filed affidavit.
Well, we had filed, we have done the needful.
He has, your colleague was there. He has submitted that since the interim order has already been passed and action has been taken by DC to defreeze those accounts. So,
But that is only pursuant to the interim directions.
Yes, so the interim direction, I think that's what I've noted down.
Well, interim direction only till the matter is heard and final order is passed. It is something like interim bail, my lord. The final bail has to be granted.
But that's where the difficulty will start. That's why I'm saying
permit us to file an affidavit, my lord.
The difficulty will stem thereafter because there are 28 accounts, some 677 individuals across the country, my lord. The students.
Anyway, this court will not revert back to reverse the earlier order passed.
That's what I'm only pointing on, because my learner senior friend is here wanting to make an argument that more than something is still surviving. If he has, my lord, done the needful as per the interim orders also, my lord, if they have to take action, they have to take action as per the law. That is only my argument. I can't stop them from doing anything as per law.
That's a 2 weeks time. We will file affidavit, the matter will be heard. The final order will be passed. If it is in their favor, there is no.
Otherwise, nothing survives as of now. He has done the status quo, entire defrozen the account.
Right. But you have also not, you see, it would have been proper for you also to have filed the relevant communication where you have, communicated to the bank that the accounts are to be.
In fact, it's quite voluminous. 2 weeks of time we will.
It's a 80-page, I think, not more than a very small petition. 90 odd pages. That's
as of now, you are still protected.
Yes.
So
grateful.
It will remain. I pop on to you, Dr. Elmuzika, Senior Counsel appearing for the state, sought for some more time to file the counter affidavit.
Have it after 3 weeks, my lord, because the other matters also there.
Accordingly, as prayed for, this is matter of 3 weeks.
Grateful.
Item number 2.
Here in this case, Lordship, subsequent developments are there after this judgment. If your Lordship permits, may I place, Lordship? First, on order, your Lordship may kindly see. This is the order. One case was pending, that Mohammed Russell C versus State of Kerala. So here, this initially interim was granted. This order is there, that I have placed. Now thereafter one order was passed. Why I am placing this? This is subsequent order. Now I have handed over to your Lordship. Here this similar view was expressed, that paragraph 7 and 8. I am not reading out that this is the same view, that parties has to approach session judge first. So this view has been expressed, and this order was passed on 8/9/2025 prior to the judgment which my learned senior friend has relied. That order was passed on September 17, 2025. So prior to that, this order was passed, and bench is similar bench, that Honorable Justice Bikram Nath and Honorable Mr. Justice Sandeep Mehta, same bench. And this case was pending before that Honorable Supreme Court, Lordship, and the judgment which my learned senior friend has relied, that matter was disposed of. Now, during pendency of that case, Lordship, and while this the citation which is placed before this court was circulated, Lordship, other counsels that placed before that court, that similar contradictory view is already expressed by the Honorable Supreme Court. Therefore, the view expressed by the Honorable Supreme Court that parties has to approach the Supreme Court is contrary to the coordinate bench order. So, accordingly, Lordship, this order was passed 12/11/2025. Last order. Just now I have given you. 12/11. 12/11/21. This matter requires to be heard by a three-judge bench combination. As and when the three-judge bench is constituted, the matter may be listed. Why I am placing, Lordship, that initially there was a division bench judgment of Honorable Guwahati High Court, that parties has to approach before the Honorable Session Judge, then only they can approach the High Court. In exceptional circumstances, they can. That was the order. That order was challenged by the Bar Council, Bar Association of Guwahati High Court before the Honorable Supreme Court, and that order was stayed by the Honorable Supreme Court that this requires clarification in the matter. So that order was stayed. That order was not placed before the coordinate bench. That issue is pending, so contradictory view cannot be taken. Therefore, Lordship, the bench which passed the order in Jagdev Prasad, which my learned senior friend relied, that bench subsequently referred the issue to larger bench, Lordship. So that probably is not a bar for me to approach this Honorable Court directly, Lordship. In view of Pranay Sethi judgment, Lordship is aware that Pranay Sethi judgment says that if any Lordship subsequent previous order was not considered by subsequent judgment, then that will be not binding.
But you say that in the judgment,
Lordship,
referred to by the learned AG,
Lordship, subsequently
that bench
Lordship
has referred the matter to a three-judge bench.
Three judges bench.
Where is that order?
Three judges bench. 12/11/2025. That I have. No issue. High Court order.
Oh, this is the same. This is Mohammed Russell.
Lordship.
Yeah. Which is
no, that is different, Lordship. That
this
Jagdev Prasad. Jagdev Prasad is already disposed of, and in the Russell case, Lordship, that was pending prior to that judgment, Lordship. And in that case also, Honorable Supreme Court initially expressed the similar view that party have to approach the Sessions Court first. Subsequently, when it was brought to the notice that a contradictory view is there before the same court, then this matter was referred to larger bench. And in my humble submission, Lordship, this order which my learned friend is relying, this was passed without considering the earlier orders. So this cannot be the binding precedent for this honorable court. And the earlier order I am just placing before your Lordship. So, High Court order to diya. Stay. Last order to diya. Last order. So I am handing over the Honorable Guwahati High Court order, then stay order, and the last order, Lordship. This is on the similar issue.
Yes.
That in BA number 3024, the similar issue, similar view was taken. That paragraph 19, page 15, your Lordship may kindly see. I'm just taking to the operative part, Lordship. In view of the reasons and discussions made above, it is held that normally a person accused should exhaust his remedy under section 138 or 439 of the CRPC before the session judge before making an application before the High Court under section 438 or 439 of CRPC. However, in exceptional illustrated circumstances, a person accused can approach the High Court without exhausting his remedy before the session judge. So this order was challenged by the Guwahati High Court Bar Association. That BA number your Lordship will get in the order of the Honorable Apex Court. BA number 3024 of 2014. Top portion it is in the order, it is written of the Honorable Supreme Court. Last order also I have given.
19?
Yes, 19/2017. Yes. In top portion case number is there, and down below your Lordship will get that impugn order was stayed.
Okay.
And the last order of that case I have given 1/3/2023. Here also said the issue raised in this appeal. Lordship got it?
Yes.
In this appeal is whether the High Court exercising jurisdiction under section 439 of the Code of Criminal Procedure 1973 has discretion not to entertain such an application on the ground that applicant must first apply to the Court of Session. In our view, a decision on the aforesaid issue would have wide ramification. Therefore, at the oral request of the Learned Counsel for the appellant, we deem it appropriate to implead Union of India as a respondent in this appeal. Let notice of the appeal be served on the office of the Learned Solicitor General of India, returnable after 6 weeks. In the meantime, liberty is granted to serve the advocate on record representing the central agency. So that issue was already pending, so that was not brought to the notice of the Honorable Court. And therefore, the said bench, Lordship, referred the matter to larger bench, Lordship.
Yes.
And in view of Pronaseti, Lordship, a judgment which is passed without considering the earlier judgment, that cannot be relied on. I have given that citation, Lordship, the book, paragraph 21, Lordship may kindly see.
Paragraph 21?
Right here. No, right here, the citation.
Yes. Citation to likha. Paragraph 21, Lordship may kindly see.
2017.
Constitution judgment has been referred here.
Yes, sir.
Yeah. Paragraph 21.
Para?
21.
28 is also important.
28 is also important, Lordship. 21 here, Lordship, that Constitution bench has been referred.
What does it say?
Yes, in Chandra Prasad versus State of UP, another constitution bench dealing with the concept of precedence states thus: the doctrine of binding precedent is of utmost importance in the administration of our judicial system. It promotes certainty and consistency in judicial decisions. Judicial consistency promotes confidence in the system. Therefore, there is need for consistency in the enunciation of legal principles in the decision of this court. It is in the above context this court in Raghuveer Singh held that a pronouncement of law by a division bench of this court is binding on a division bench of the same or a smaller number of judges. So earlier that judgment was not considered. It will not consider paragraph 28. 28 ঠিক আছে index we may also refer to hearing তাতে লিখি দিয়া আছে and paragraph 28 lordship may kindly see in this context
this judgment is pronouncement of law by a division bench
of same court lordship
is binding on a division bench of the same court.
And here why I am pointing out because earlier there was a judgment which stayed the impugn order of Guwahati High Court saying that it requires elaborate discussion. So without taking into consideration of that case lordship, this impugn order was passed. So therefore my submission is that that is not binding, and therefore lordship may kindly have a look at paragraph 28.
Yes.
In this context, we may also refer to Sandeep Kumar Bafna versus State of Maharashtra, which correctly lays down the principle that discipline demanded by a precedent or the disqualification or diminution of a decision on the application of the par incuriam rule is of great importance, since without it, certainty of law, consistency of rulings, and committee of courts would become a costly casualty. A decision or judgment can be par incuriam any provision in a statute, rule, or regulation which was not brought to the notice of the court. A decision or judgment can also be par incuriam if it is not possible to reconcile its ratio with that of a previously pronounced judgment of a co-equal or larger bench. There can be no scintilla of doubt that an earlier decision of co-equal bench binds the bench of same strength. Though the judgment in Rajesh's case was delivered on a later date, it had not apprised itself of the law stated in Reshma Kumari, but had brought guided by Santosh Devi. We have no hesitation that it is not a binding precedent on the co-equal bench. So that is my humble sense. So there is no bar in entertaining in my application lordship, although already that issue is pending before the Honorable Apex Court lordship, and the earlier judgments were not decisions were not placed before the court lordship, although which bench were considering that same aspect lordship, and therefore the same bench lordship referred the matter to larger bench when it was brought to the notice of that court.
Yes, Mr. Shubhai.
May it please your lordship. Lordship, this is the Kerala, state of Kerala, which I was mentioning before your lordship. Lordship, kindly have para 8 and para 9 of that order. This is the order of 8/9/25.
You are referring to?
Lordship, this is Muhammad Rasal, versus state of Kerala. Lordship, kindly have para 8 and 9. May I read it, your lordship?
Yes.
We further feel that if the practice of entertaining the application for pre-arrest bail directly in the High Court is encouraged, and the parties concerned are not regulated to the first approach the session court concerned, the High Court would be flooded with a state of pre-arrest bail application, thereby creating chaotic situation. We say so because if the parties are required to approach the session court concerned for seeking remedy of pre-arrest bail, there is a strong probability that significant number of applications would be allowed at that level only, thereby acting as a filtration process before the process reaches the High Court. It is right that in most of the states there is a practice requiring the litigant concerned to first approach the session court for seeking relief of pre-arrest bail, and only in the event of denial of such relief, the litigant would be granted access to approach the High Court for seeking relief. This, of course, subject to just exception, Lordship kindly see, and the High Court, for reason to be recorded, may entertain an application for pre-arrest bail directly in the special and extraordinary circumstances. Your Lordship, here, Your Lordship, what are the special and extraordinary circumstances, Your Lordship? Kindly see, Your Lordship, the charge sheet was filed on 15/9/2025, Your Lordship. Now we are in April, Your Lordship. in April 26, Your Lordship. So where is the apprehension, Your Lordship? Where is the apprehension, Your Lordship?
Charge sheet file on?
On 15/9, Lordship, kindly have, Lordship, that is, Lordship will find it at page 138. Page 138, this is filing charge sheet number 05 of 2025, date 15/9/2025, Lordship. So where is the apprehension, Your Lordship? Now we are in April 2000, we are marching to May 2026, Your Lordship. Where is the apprehension? Where is the reasonable apprehension, Your Lordship? Then, Lordship, then come that Jagdiyo Prasad, same thing, reiterate what has been said, Your Lordship, in Muhammad Rasal, Your Lordship. Until unless, Your Lordship, that though the bench had referred to constitution bench of 3 judges, Your Lordship, as it stand now, Your Lordship, these two order, Jagdiyo Prasad as well as Muhammad Rasal, would stand, Your Lordship. Would stand, and as such, the bail applicant, Your Lordship, is required to first approach the Learned Session Court, Your Lordship. And only if the Learned Session Judge, Your Lordship, refuses the bail application, Your Lordship, then he can come before Your Lordship. That is my humble and respectful submission, Your Lordship. So far, this point is concerned, Your Lordship.
So what about
Only thing just I'm pointing out that my apprehension comes only after filing of the charge sheet, Lordship. My case is that prior to that I was cooperating in the investigation, Lordship. Even in fact there was an inquiry before the SP office, Lordship, conducted by Additional Deputy Commissioner, and I was directed to appear on 4th August 2023. That letter also I have enclosed, and in connection with that I also appeared before the SP office personally. Then also I was not apprehended, Lord. Subsequently, when I have been shown as absconder, only because of that, after filing of charge sheet, I am apprehending, Lordship.
Fine. The party that passes yours.
Lordship, highly apply, Your Lordship.
Okay.
On daily list, item number 6.
My Lord, this is, my Lord, where we have challenged the punishment, my Lord, of granting 14 days rigorous imprisonment, my Lord. My Lord, I pray that if it matter can come next week, my Lord.
But that 14 days is over.
My Lord.
Now he's, after that, what happened?
My Lord, after that we have challenged that.
No, no. After
He's back to service.
He's in service now.
Still in service.
He's in
not
service.
not
No.
discharged.
No. There was nothing with
nothing
regards to
remains
the
on the
dismissal
justice,
order.
no?
Concerning after punishment, there is nothing on the
Will that you see that period of his imprisonment?
my lord.
Will it have any bearing on his?
My lord, in the service career, because
career.
what happens, my lord, that 14 days, it terms as a reading entry, my lord, in his service record, my lord.
Or reading entry.
Reading entry, my lord. So if
There are 4 reading
for
entries,
reading it, then he's out of service, my lord. So for that reason, we are challenging it, my lord.
Because he's asking for 2 crore compensation in the prayer number 2.
But that means it is the punishment is if it is illegal by a authority which is not competent, my lord. That's why we are subject to 2 crores of
whether
rupees, my lord.
service matter,
That will be the highest amount of compensation ever awarded. My lord.
tortious liability, maybe.
Well, definitely.
Just have to, then you have to prove that during imprisonment you were tortured, shot.
that is there on that itself.
Premier with parties, this is matter after 2 weeks.
Hello.